This is in column 3 of the second schedule. At the reference to the elected members of the legislative assemblies of the state and to each such, has the Lordship got it, man?
Yes.
And to each such elected member shall be deemed to include respectively a reference to the members of the Constituent Assembly of the state.
Because there was no legislative assembly at all.
No legislative assembly. I'll show you. There was no, absolutely right. There was no legislative assembly at that time. But even when there was, so that's the whole point. The point is, it was deemed to be a legislative assembly for the purpose of our constitution. Why was this necessary? In 55, they were trying to get members of the legislative assembly of Jammu and Kashmir.
Right, which is the next point, which
Yes.
is the next article,
The next order. So by a deeming fiction, the legislative assembly members of the
Give us
constitution.
the next one because we are now
Yes.
5 minutes short of the.
Yes. Then next one is CO 39. That's at PDF page 10. See, volume 3 again, PDF page 10.
CO 39.
PDF page 10.
Yes.
Reference to the elected members of the legislative assemblies of the states and to each such elected member shall be deemed to include respectively a reference to the members of the Constituent Assembly of the state and to each such members. However, in CO 48, which is the next one, I'm running through it now, and this was in 1954. The date of CO 48 is 15th May 1954. But in this CO,
That CO you're saying?
so that's about volume 3, PDF page 13. And I'm reading at page 18.
That is CO number?
48, dated 15th May 1954.
Right, that's a 54. Page 18. All right.
Now, in this CO, for the first time, previously it was done by COs. But for the first time, Article 367 was amended
Right.
as applicable to J and K.
Was it relevant for your argument that Constituent Assembly means Legislative Assembly?
Because that's what the Union of India has done. They have amended 367.
It's clause D.
Yes, yes. That's CO 272, which is under challenge. The same procedure was done, was undertaken in 1954. For the first time this was done.
This was also pointed out to us by, I think, the learned solicitor.
In fact, that's in his list of days. It's the first exercise of 367 power.
But it was even, yes. But even earlier, they were synonymous. The Legislative Assembly and the Constituent Assembly. It emanated from 1948.
This 14th of May 1954.
Yes, 15th of May 1950.
Right. When there's no Legislative Assembly in Jammu and Kashmir.
No, it's not. But now an amendment is made that they will be the same. Even when there's no Legislative Assembly. And now we are not talking about for the purpose of a presidential election. This is now for every purpose.
All right. Which is the next CO?
Then, my Lord, Your Lordship might just see a provision in the Constitution of Jammu and Kashmir, 85(2), 85 subsection 2. This is at PDF page 56, volume 2.
Page?
PDF page 56. Until rules are made under subsection 1, the rules of procedure and standing orders in force immediately before the commencement of this constitution with respect to the Constituent Assembly while discharging the functions of the Legislative Assembly shall have effect in relation to each house of the legislature. There was only one. Subject to such modifications and adaptations as may be made therein by the Speaker of the Legislative Assembly or the Chairman of the Legislative Council, as the case may be. My Lord, substantively and in matters of procedure, the Constituent Assembly and the Legislative Assembly. In fact, what emanates from all this is that the Constitution.
But Mr. Jetnani,
Yes.
the fact still remains that after the Constitution of Jammu and Kashmir was framed
Yes.
on 26th of January 1957,
Yes.
Article 367 4D was again amended.
Yeah.
So delete clause D.
Yes. But my Lord, that.
So that equivalence between the Constituent Assembly and the Legislative Assembly ceases the moment the Constitution of Jammu and Kashmir is framed.
Lordship is absolutely right. Now I'm coming to that last one in 58. That's the last piece. But my Lord, what happened is.
That you will find at your volume 3, page 25.
Yes, Your Lordship is at page 25. That's. The point is, all this shows that the Legislative Assembly, and why was this deleted? This was deleted because after the dissolution or the extinction of the Constituent Assembly, the constituent power in Jammu and Kashmir was now the Legislative Assembly. The power of amendment, in Article 368, it's in virtue of its being a constituent power that Parliament can amend. This is also recognized by at least 3 judgments in Indira Gandhi's, Nehru's case with Raj Narayan. I go back to the beginning of what I said, right at the outset, that the idea was that 373 being the final step, after which Article 370 altogether ceased to exist.
The only distinction is that a legislature which exercises the power of amendment is not a Constituent Assembly. It's exercising a constituent power.
I agree it is. But otherwise, the alternative interpretation would be that abrogation ceases to exist. You can never abrogate Article 370. That would be the alternative conclusion. We have to see why Parliament amended to Article 370 through 367 in the manner which it did. That's the whole challenge to 272. That is the whole challenge. And it did so because not only was it synonymous they wore 2 hats. The Constituent Assembly wore 2 hats. The same people, the 75 people who constituted the Constituent Assembly in 1951 when it was convened, were the same people who were also members of the Legislative Assembly.
Argument of the learned solicitor is that independent of the amendment of Article 367,
Yes.
370 bracket 3 and the exercise of that power still stands.
Of course it stands.
And it still survives.
Because I'll tell your Lordship why.
Have to go as far as, according to him, he has not pitched it. Though he said, look, 367 has also been used in the past.
Yes.
To the 3 times it was used.
Yes.
But he has said, independent of 367,
It can still be done. Look, which is why I come to my next point. And that's one of the 367. They became the successors, They were certainly the successors. If there was any constituent power which could replace the Constituent Assembly in the proviso, it was certainly only the Legislative Assembly. Now, your Lordship is right, 367 could not be the source for That did not necessarily have to be the source for that replacement between the Constituent Assembly and the Legislative Assembly. Did not have to be a source. But it was implicit in any event. All 367 did, or the amendment to 367 did, by CO 272, was to recognize an implicit position. It was not only synonymous for a substantial period of time, but it was a successor. And CO 272 did not make a substantive change. It made a change it was a clarificatory change, which was already inherent, which was already implicit in Article 373 proviso.
Right. Anything else, Mr. Jepalani, now?
So now the Damnu's case applies. One look at Damnu to consolidate this argument.
Damnu we have seen, we'll have a look at it.
Just some paragraphs with special emphasis.
Which are the paragraphs? Just give us.
Yes, I'll give your lordships the paragraph. Paragraph 25. Oh, no, I put it in my list. Lordship, just give me a minute. Yes, my lord, the factual situation, which my lord makes the question of law decided clearer, is in paragraph 6, 1, 7, and 8.
Damnu.
Of Damnu. That's the factual situation. But if your lordships recall, it was that change. It was that change of Sadr Riyasat to the governor of Jammu and Kashmir. And the findings are at 19, 22, 19 to 28. 19 to 28. Another 367 was upheld by that constitution bench. The amendment to 367 was upheld by the constitution bench on the ground that it was merely a clarificatory. It was not an amendment of substance. So also here, I bring my submission within the four corners of Damnu.
All right.
That this was inherent.
Anything else, Mr. Jepalani?
No, well,
because now the second point you have covered is.
Well, and as my learned friend pointed out, that Damnu also refers to it. Damnu says it's sought in aid of its judgment, section 18 of the General Clauses Act.
Yes.
So, my lord, General Clauses Act applies because it's my contention that the Constituent Assembly is the successor. The Legislative Assembly is the successor, and section 18 of the General Clauses Act will squarely apply, as it does. So the powers vested in the original authority will devolve to the successor authority. In this case, the Constituent Assembly, the Legislative Assembly.
Thank you, Mr. Jepalani. Thank you, Mr. Jepalani. Yes, Mr. Guru.
Made these. I appear in IEA Melod's 9596. WP Melod's 1037 of 2019. Melod's, just a minute, Melod's aside.
Who are the applicants?
The applicants, Melod's, are persons, displaced persons from that portion of Jammu and Kashmir, which is now called Pakistan occupied Jammu and Kashmir. They represent that set of people, Melod's, and their interests. These are the interveners. With prejudice to my time limit, which my lords have given, just an aside, my lords. I'm reminding myself of being that apocryphal son-in-law or Hindu law, my lords, which Sir Alladi referred to. Apparently, my lords, there was a very intricate problem of Hindu succession under Mitakshara and Dayabaga law before an English judge. The questions were getting so complicated that the judge tongue-in-cheek asked Sir Alladi, what would the son-in-law get? I believe Sir Alladi said whatever he is able to lay his hands on. That seems to be my position in terms of both time and submissions to really.
So what are the key submissions?
Key submissions, I'll refer to this one also. The rights perspective is probably the decisive factor in determining, my lords, the tenability of the challenge which has been mounted by the petitioners. In other words, my lords, the rights perspective will trump or override all or any contentions or allegations of processual infirmities. The reason why I'm making this submission is this, my lords. Whether it be these intervening applicants or any of the other intervening applicants whom Mr. Salve represented, Mr. Giri represented, or for that matter, Mr. Jethmalani represented, they represent a cross-section of people from Jammu and Kashmir who have suffered discrimination and loss of rights. Therefore, they impugn COs which make provision for rights for such people across the spectrum. The validity will have to be seen in that perspective and in that light. That's my submission for my lord's consideration. For example, my lords, these intervening applicants whom we are referring to, they are probably, my lords, the first victims of the problems which occurred during partition. When the aggression took place and the incursion came, these are the persons who were displaced by force of circumstances from those areas, Mirpur, Gilgit-Baltistan and all those places. They moved therefore to other parts of Jammu and Kashmir and to other parts of India. Now, what is really the problem that they have suffered over the decades now? Because of Section 6 of the Jammu and Kashmir Act, Jammu and Kashmir Constitution, and 35A of the Constitution of India is applicable to Jammu and Kashmir. 6 purported to set out who permanent residents are. (35A) introduced, my lords, by constitutional order in 1954. CO 48. That, my lords, provided that permanent residents, as defined in 6, they will get certain benefits. And the fact that persons who are not permanent residents will not get those benefits cannot be called in question as a matter of justiciability.
Guru, just one clarification.
Yes, Manoj.
People who came from the Pakistan occupied Kashmir,
Yes.
they were not given rights under 35A?
No, for the reason why, I'll tell my lords why. Because that referred to permanent residents. Permanent residents as defined in the Act is any citizen of India, but subject to 3 important riders. Rider number 1. The person must be a state class citizen 1 or 2 as of 14th May 1954. 1. 2, he must be ordinarily resident in the state of Jammu and Kashmir during a period of at least 10 years prior to that date. So the date is shifted back to 1944. That therefore, my lords, meant that even those who were there citizens in Jammu and Kashmir in their own right, because of the external aggression during September, October of 1947, they are excluded. That's where the pinch is, my lords.
If they had settled down in other parts of the country, they would have got citizenship.
No, they would have had to be only.
Other parts of the country.
Yes, they won't get. If you're in Jammu and Kashmir, yes. But if you went to other parts of the country, you won't get.
Sorry, you're saying
Yes.
the other way around.
May I show 6, my
You're
lord? May I
saying
show...
the other way around.
No, may I show 6, my lords? Can I show 6? Give me 6. Just give me 6.
Jammu and Kashmir Constitution is in part 1
Yes.
of the document. Part 2. Part 2.
Volume
1 and 2.
2, my lords, page 18.
Well, I'm sorry to interrupt. There are 10 petitions here which challenge 35A. Well, those have to actually be de-linked because we're not here concerned with the challenge to 35A. We're concerned with 370. So, Malas, all that is fine, but that's not to be decided by your lordships. If, Malas, if this is upheld, if what the union is saying is upheld, this is unnecessary.
That's why.
Doesn't exist.
Mr. Simple, therefore we are going into this.
I'm only saying, Malas, this is only
let's-
take up the
let
time
me-
of the court. That's all.
Every person, I'm at Malords, volume 2, PDF page, Malords, 18. Every person, may I read it, Malords, is deemed to be a citizen of India under the provisions of the Constitution of India, shall be a permanent resident if on the 14th day of May 1954, he was a state subject of class 1 or of class 2, or having lawfully acquired immovable property in the state has been ordinarily resident in the state for not less than 10 years prior to that date. Any person who before the 14th day of 1954 was a state subject of so and so, who having migrated after 1st day of March 1947, this is an anomalous provision. I'll just show that, my lords. So the first part is 6.1. That talks about two dates, 1954 and 10 years prior to that. Second,
It's an alternative. A and B is an alternative.
that's right. Or, that's right. That's right. But then in terms of actual application, they have always been applied together. All these are persons.
They have been applied, treated as cumulative.
Yes. You are outside Jammu and Kashmir. You don't get it. In fact, I've given in my application, my lords, the case of how 8,700 people and odd people left that place during that time, during partition. Today, my lords, after the promulgation of the impugned COs, at least 23,000 people have received domicile certificates. About 24,000 people. We have mentioned that in our submissions.
So state subject of class 1 or clause 2
Yes.
is defined in clause 3.
Yes.
Subsection 3.
Yes.
Namely, that refers you to
1927.
So
That's right.
you're out there.
Yes.
You don't come in there.
No. In fact,
Clause 2.
no, because by 47, by 44, what happens is this, my lords. They expect you to be holding property as of 1944. And even though I qualify, in fact,
Let's say in POK, they're not governed by clause 3 of section 6.
no, my lords, what will happen? They will be governed by clause 3. That's why I'm saying it is applied cumulatively. You should be a state citizen, state subject of class 1 or class 2, and you should have been holding.
It says or.
No, but cumulatively it's being applied where you should have held property as of 44.
But then, Mr.
No, all I'm saying is this.
Mr. Kishore, I don't think 2 can be read as cumulative because it imposes a condition of
No,
owning a whole property.
No, I follow.
That owning property.
No, no, I understand. But the fact of the matter is,
It cannot be.
the fact of the matter is, my lords, they were entitled, but they have not been provided. That's the factual position.
Only thing is because under A and B, if you're not under A, if you're class A and class 2 citizen, then you have to go for 1927.
1927.
Get documents of 1927 will be very difficult for anybody.
That's another aspect, absolutely. I bow down to that.
Now in clause B, prior to that date refers to which date? 14th of May, 1954?
Yes, that's right. 1954. That 14th of May, 1954.
Yeah, for clause A, subsection 3 applies.
That's right,
That is
27.
the 1927 order.
Correct.
For clause B, you have to own property and you must have been ordinary resident at least for 10 years prior to 14 May 1950.
I bow down. And
So
that date,
anybody from 14th of May 1944 onwards
that's right.
comes within the
Should
purview
have
of
held
clause
property. And that 1954 date, my lords will recall, is the date of CO of 1954.
That's also very odd because to
Yes,
say that you must own a property to get citizenship.
exactly. Now, one more thing, my lords, one more aspect, my lords. Please have a look at 2, section. Yeah, that's right. It's a
You're really trying to say is you're supporting the CO 272 and 273
correct.
by pointing out the anomalies which would otherwise arise as
I
a
bought
result
on-
of Article
I bought
35,
on.
Section
The
6 and 35.
I bought on the challenge, my lords, would really mean that they want to resurrect, amongst other things, this and 35A. That's the point.
Of course, challenge to 35A has.
It stands, it stands. But
Kept aside.
I bought on, my
An
lord.
application to assist. Otherwise, that challenge has been kept aside to await the fate of the decision.
I bought on, my lords. But then
Provision-
I am saying
provision-
that this is important.
A provision which doesn't exist as of now cannot be challenged.
No, that's true. The effect of upholding the COs is to ensure that, my lords, this anomaly doesn't exist anymore. I am respectfully submitting, my lords, that I am placing this submission from the perspective of rights which are being made available by the impugned COs. That's the point I'm making. One more anomaly to add to what fell from my Lord Justice Khanna may have a look at it. Section 2, subsection 2. Any person who before the day of 1954 was a state subject of class 1 or class 2 and who having migrated after the 1st of March 1947 to the territory now included in Pakistan returns to the state under a permit for resettlement in the state or for permanent return issued by or under the authority of any law made by the state legislature shall on such return be permanent resident of the state. So you make an exception out of this by saying those persons who may have gone to Pakistan, if they come back, they'll get the benefit.
Any persons also who was.
Yeah. The anomaly is writ large.
No, this included in Pakistan will not include Pakistan occupied.
No, it won't. That they are very clear.
It will not include Pakistan.
No, it won't. That's why a separate provision is brought in.
It will be portions other than.
Other than
Pakistan.
POJK. There is one other, my lords, very ironical aspect. The Jammu and Kashmir constitution makes provision for seats for POJK in the assembly, but says because it is under. 1 minute.
Time is up.
I know, my lords. That's why. Now there are two other perspectives I'll place and then I'm done, my lords. In fact, this is something which nobody has referred to. That's the reason why I'm even troubling my lords with some of the nitty-gritty of this, my lords. So this is one aspect. 35A, just have a look at that for a minute, my lords. Now, because there's a striking parallel to 31B under the constitution. Koilo, please see the kind of dilution which took place in Koilo. Just have a look at 35A for a minute, my lords. This will be volume 1, PDF page 99. Okay. May I read the words? Notwithstanding anything contained in this constitution, no existing law in force in the state of Jammu and Kashmir and no law hereafter enacted by the legislature of the state defining the class of persons who are or shall be permanent residents of the state of Jammu and Kashmir or conferring on such permanent residents any special rights and privileges or imposing any other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or rights to scholarship or such other forms of aid as the state government may provide shall be void on the ground that it is inconsistent with or takes away or abridges rights conferred on the other citizens of India by any provision of this part. Now, 31B, my lords, under the constitution provides that anything included in the 9th schedule shall be immune from challenge on grounds of violation of part 3.
Guru, now I also note that in your written submissions, you have
Yes.
really highlighted, what was the anomalies and what has been restored now.
Exactly.
The rights perspective. So
That's right.
I think let's go into the
Just
next slide. Yes.
three more things, my lords. I'll take only 3-4 minutes, my lords. Now, 31B in Koilo, my lords, very extensively referred to the foundational value of the fundamental rights. Golden triangle of 14, 19, and 21. I've given all those paras in my submissions, my lords. In fact, I've given the extracts of all those paragraphs in Coelho. Now, ultimately, my lord said, you cannot take away judicial review and any law included in the 9th schedule can be tested on the anvil of basic structure. Now, surely you cannot have a position, and that's what petitioners are bargaining for. What was there in the original constitution, my lords, this is the approach of this honorable court. The petitioners can't bargain for a position where the Jammu and Kashmir constitution, which is admittedly inferior in terms of, my lords, the constitutional governing instrument than the Constitution of India. They have something better than that. This is the kind of importance which has been given under the constitutional scheme of India. In fact, 31B itself, my lords said at one part in paragraph 78, just make a note of it, the validity of 31B was not in challenge and therefore my lords did not go into it. My lords assumed that in Shankari Prasad and in Sajjan Singh it was upheld, therefore my lords didn't go into it. But instead, judicial review cannot be excluded. And you cannot say, by placing it there, I'm making it immune to challenge. That's precisely what 35A purports to do. That's the second part, my lords. Third part. Ultimately, my lords, all the nuts and bolts and the nitty-gritty looked at. What does it come down to, my lords? The basic structure is the ground norm. That's the touchstone on which any constitutional decision making has to be considered. The validity of any constitutional decision making has to be seen. Today, what are they, my lords, arguing in terms of basic structure? At the highest, apart from, if I may say so, diffuse arguments of fraud on constitution. Two square features which they want to invoke, my lords, in various forms. One is federalism. The other is, my lords, representative government. So far as representative government is concerned, I think that already the solicitor has pointed out, it's a Puducherry model, there is representation. So far as federalism is concerned, the highest that they are able to put it on is some kind of a derivative form of federalism based on what my lords have said in the 2023 NCT judgment. That's the highest they want to put it at, where they say that my lords are referred to an asymmetric federalism. Paragraphs 40 and 41 of 2023, my lords have been given, the citation is there in my notes of submissions. What they want to say now is, asymmetric federalism has been recognized. Now please stretch this and say, the multisymmetric federalism of 370 should also be taken to be a basic feature of the facet of federalism. That's the argument. I'll give the page numbers of Dr. Dhawan's arguments. Page 280, page 211, volume 1 of submissions. After extracting from my lord's decision in NCT in 2023, they say that this now has to be stretched further to say multi-symmetric federalism. There, para 40 and 41 of 2023 at the risk of carrying coal to Newcastle, my lords. My lords, interestingly, have referred to 371 and all those provisions for various states by way of special provisions. My lords there refer to how they are special provisions in 371. And it is on that basis, by relying on the marginal note. My lords have pointed out how constitutionally some kind of asymmetric arrangement has been made. So it is on the basis that it is a special provision in 371. Today, what they want to do is equate 370, which is temporary, with 371 special provision. I hope I make myself clear.
Yes.
Therefore, that is why I said it's a derivative argument they want to make. 371, my lords consciously referred to the marginal notes and said how these are special provisions, and that's how they provide for special provisions. That cannot be stretched, my lords, to say that it has to be applied to 370. The temporary character, nuts and bolts of 370, all of them have been argued, my lords. I don't want to take the time anymore. I'm adopting those arguments. In the light of that, my lords, I would respectfully submit. In fact, the impugned COs are reflective of transformative constitutionalism. What was argued by Dr. Dhawan, in my respectful submission, the boot lies on the other foot. The impugned COs ensure that the Constitution of India, with all its plenary scope, applies to the state. In my respectful submission, my lords, the challenge of the petitioners is really a contradiction in terms. Because this is a case where the application of the Constitution of India, the plenary document, is sought to be challenged. The effect of the COs is to ensure that the entire Constitution applies to the state, with all Part 3 rights, with all the other provisions. And even on federalism, my lords, there is one other portion in the opening remarks of Dr. Ambedkar while placing the draft constitution, my lords, before the assembly, constituent assembly. I've extracted.
Extensively read it.
No, there is another portion apart from what Mr. Giri read. So I've extracted that in my submissions. My lords could have a look at that.
We'll see it.
Therefore, my lords, in sum and substance,
Thank you, Mr.
in sum and substance, my lords, this is for perpetuation of vested rights. And the COs, my lords, make provision for realization of rights under the Constitution. I'm obliged.
Thank you, Mr.
Yes.
Who are you appearing for?
I am for the writ petitioner who had filed the writ petition in January 2018 against the effacement of all articles in respect of me in relation to Jammu and Kashmir. Part 3, effacement of Part 3, a core value from the Part 3. I challenged that before this court and that has been tagged. Enough has been argued, but I am arguing for class, that's Radhika Gill versus Union of India.
Which is that?
Radhika Gill versus Union of India, and my synopsis is at page compilation is 426. I take only 2 bits, my lord. This Radhika Gill and the other person belongs to that class who are descendants to those persons who had been lifted from Gurdaspur to Jammu and Kashmir in 1957 to handle the sanitation problem which had arisen on account of the long strike in Jammu and Kashmir. So they were settled in the outskirts of Jammu and Kashmir, and my lord, that now has converted now with the passage of time. Those are the slums, no property rights, etc., no education rights, etc. Now, my lord, your lordship may kindly see my prayer. The whole effacement of Part 3 in relation to Jammu and Kashmir, I have challenged in my writ petition. Your lordship may kindly see the Solicitor General referred to Article 14 effacement also. Your lordship may kindly see 35A Clause A. What exactly it does? It does one thing, my lord, delegating the power to the state legislature to define the permanent resident and not challengeable. That's what, my lord, the delegation has been done to the state government, state legislature, my lord, in this class 1, your lordship, defining the class of permanent resident and delegating it to state legislature and not challengeable. So, my lord, your lordship have not allowed such a delegation to the state government so far as the Part 3 aspect is concerned. So that's what the solicitor said, that core value of Article 14 has also been taken away. And with the aid and assistance of this delegation, Section 6 was incorporated, and this is nothing but a homage to defined ancestry and none else. Whosoever is there on a particular cutoff date, I was there in 57 only, my lord. So my predecessors were in 57. And we were there, and now we are denied. I am born there, and at least no fundamental rights are available to me. That's why I challenge that right to education. Section 6 has also been challenged in that petition. Now, your lordship, I am now, so far as my synopsis is concerned, paragraph 17 and subparagraphs have dealt with 3 aspects. One is the powers precedent are constant in nature. The lordship may kindly see paragraph 7, subparagraph B.
That's been argued. That's been
now, one thing. Relationship between 368 and Article 37.
That's been also argued. Yes.
No, yes, I have taken this. I have taken this here in that.
Thank you.
Thank you. Anything else? Yes. Yes. What about you?
I am appearing in, my lord, I number 153121.
I number?
153121.
15153.
153121 of 2019. That's Roots in Kashmir. Roots in Kashmir is an organization which is espousing the cause of Kashmiri migrants
now called displaced persons, my lord, since 1989, there are 5 lakh people.
What is the submission?
That's one, but that's one petition. Number 2 is, my lord, Dr. Charu will Khana, my lord, that's a substantive writ petition in 2017, my lord, 369. Lord, that is, just give me number, uska number kya hai? 396 of 2017, my lord. Submission is, my lord, I am, my lord, given detailed written submission that are conjoined written submission, my lord,
Page,
volume 3, page 444 to 456. And, my lord, for convenience, my lord, I have filed a small note, 3-page note, my lord, which was taken on record, my lord. I read it, my lord.
But we'll have a look at it. But you can just sort of in 1 minute just highlight what is the central point.
My lord, I'll say, my lord. I'll say, my lord, the instrument accession dated 26/10/1947, my lord, is final and issue of proclamation, and the Article 1 and is completely applicable, my lord. So it has, it's being an integral part of the, my lord, India, domain of India, my lord. Then, my lord, I say,
There
my
is
lord,
something which has not been argued.
my lord, it's not, my lord, it's not, my lord. I say, my lord, with respect to the Article 370, which has been raised, my lord, herein, that the devolution of power of Constituent Assembly is transferred to the Legislative Assembly, as there is no Constituent Assembly as on 57. Therefore, it's not the...
That has already been argued so many times.
No, it's not, my lord. It's not, my lord. Concurrence given to the government of the state, but also repository. My lord, ratification has been done to the parliament. So absolute majority, parliament has rectified the decision. One is that, my lord. 2 is, my lord, and my lord, it's not a basic structure. As my lord held in, my lord, I am going to.
Got the point.
I have, my lord, relied in my, my lord, I relied on my, my lord, 1973 for SEC volume 15, my lord, in Keshavananda Bharati of Justice, my lord, Justice Khanna. He has given that, my lord. And, my lord, then Bomai also, it's not a federal, it's a quasi-federal, my lord, state. Then Puran Lal Lakhanpal and, my lord,
That has now been covered.
modification. My lord, I had added one judgment, my lord, because I could hold that. That is, my lord, S. Sant Singh and others versus State of Jammu and Kashmir, reported in 1959, Jammu and Kashmir, page 35. That's a full-page judgment, my lord, which deals with modification clause of, my lord, Article 30, my lord, Article J&K Tenancy Act, my lord. That is AR 1959, Jammu and Kashmir, page 35. Dealing with the challenge to provisions of Jammu and Kashmir Tenancy Act inserted in 9th schedule was upheld and did not violate any of the fundamental rights conferred of Article Part 3.
We'll
See, this is, my lord. Then Coelho, as my lord said, that it's not a fundamental, it's not a violation of fundamental rights under Article Para 102. My lord, Coelho is that page, my lord.
Coelho has been argued so many times. Everybody has referred to Coelho.
Then, my lord, we have very less time, my lord. That's why, my lord, I'm just going through all these things.
To Mr. Dwivedi.
Indra Sani, my lord. Indra Sani, my lord.
To Mr. Dwivedi.
My lord, 35A, my lord, I have challenged the substantive writ petition, my lord, in 2017, which a notice was issued, and this was referred to the Constitution Bench in that time only, my lord. Then it was tagged along with this, my lord. So I have 4 judgments to cite on, my lord. Indra Sani, that's equality. 19. My lord, what has happened in this, my lord?
You put it in your note.
Well, I said, well, 27 and 32 notifications.
We have 3 minutes now. Let's hear some other people.
I'll take 3
otherwise
minutes.
we will-
I'll take 3 minutes. No,
Let's-
3 minutes. I'll take 2 minutes. I'll take 2 minutes.
No,
27.
You have to close at.
My lord, 27 and
Yes,
30.
Mr. Banerjee, what do you
I'll
have
say,
to
my lord.
say?
I'll say why.
My lords, I am,
We'll read your written submissions.
One. Then,
my lords, I am appearing in IA 146764, my lords.
my lord, just petition from my lords.
No, that absolutely not. You have to conclude. We have to conclude by lunch. I mean, we had made that clear yesterday.
My lord, my 1 minute they'll take, my lord. My lord, I'll say, my lord. I'll say, my lord.
When we
Mr.
said
Judge,
that
we have,
period of time,
My lord, I had.
We had said that, look, we are going to conclude at 1 o'clock. We had requested everybody to so structure their arguments that the others who follow have time. We are not going to cross 1 minute after 1 o'clock for
Yes,
this
my lord.
side.
My lord, I'll read the affidavit, my lord.
Absolutely.
I'll read the affidavit, my lord, which I mentioned in the morning, my lord. My lord.
You can argue for the next 3 minutes, but you know what the consequences. We are rising at the stroke of
My
lunch.
lord, I read. My lord,
Yes.
let
We
me
are
read-
starting with the rejoinder.
let me read the affidavit.
See, this is not fair. You said,
This is
I will give my
filibustering.
half an hour to Mr. Dwivedi.
My lord, half an hour to me, my lord. I could curtail my half.
Mr. Jardin
Half an
specifically
hour.
said
Give your half an hour to.
My lord, can I read
that I'm
affidavit?
giving my half an hour to Mr. Dwivedi.
My lord,
but-
can I read my affidavit, my lord?
We'll read it. What is
Read
it?
it, my lord?
We are writing at
Look,
1 o'clock.
Minutes.
In my affidavit, my lord, I am making only one submission, my lord.
The
Let Mr.
element of
Lone make
civic
a statement
consciousness
or
must also
affidavit
apply
to
to
that
legal
effect,
arguments
that
in court.
he is a citizen of India and he doesn't, my lord, support terrorist states, my lord. Let him put an affidavit, my lord. Mr. Sibbal,
That has
learned
been
counsel
put
is
by the
here, my lord.
solicitor also in the morning.
All right, 1 second.
Please.
Just 1 second now. Just 1 second.
Please.
Mr. Agarwal, what point do you want to make? Just formulate it. Come.
My lord, affidavit, my lord.
Diversity, the element of Dr. Dhawan is.
My lord, only one thing, my lord. Mr.
Please, your time is over.
President of the bar is
Your
here, my lord.
time
Jammu Kashmir president. My
Your
lord.
time is over.
My lord, I was appearing for Jammu and Kashmir High Court Bar Association. My lord, president of the bar is here, my lord. He wants to say something. That's all, my lord. I am curtailing my argument.
We are in charge of whom we will hear. You are not in charge of who will follow you.
My lord, I don't.
Mr. Kanu Agarwal.
Okay, that's, my lord, I leave it to my lord.
Short pages that I have submitted. Federal diversity, my lord, Dr. Dhawan sought to rely on the judgment of R.C. Podial. If my lord sees, to my understanding, federal diversity in the Indian constitution exists on a two-dimensional plane. At the center would, as far as I understand, would be the classical states, would be the classical understanding of a state, the state which has fully governed by Schedule 7 and other provisions of the constitution. To the right of it would be states which have limited special features, would be states like the limited features like Gujarat or Maharashtra, all taken through by Dr. Dhawan. Thereafter would be states which say fall under the 5th schedule and the 6th schedule, and some other states which have further special features. To the right end of it, perhaps, was the erstwhile Article 370. What the petitioners forget, my lords, is that there is a scale to the left of it as well. The scale to the left of it is the union territories with legislature, is the union territory of the GNCT of Delhi, and further, perhaps, pure and simple union territories. Therefore, federal diversity, my lords, it's undoubted that diversity is a constitutional fact, but not all constitutional facts can be elevated to the level of basic structure. When we adopt the identity test in terms of identification of basic structure, not all constitutional facts become basic structures. R.C. Podial was relied upon to further the argument that this diversity, a manifestation of which was Article 370, erstwhile Article 370, is a part of basic structure. Incidentally, my lords, para 128 was read in R.C. Podial. If my lord sees the last 3 lines of para 128, I think that those last 3 lines itself completely demolish the case of the petitioners on federal diversity, because those last 3 lines itself indicate that these provisions which were in consideration in R.C. Podial were for a limited transitional period. The word transitional has been used. Therefore, my lords, as far as the fact that federal diversity may be integral, it would not necessarily lead to it being a basic structure. The method and the methodology adopted by the union, whether under 368 or 373, has been fully taken care of. I don't wish to address it further. The second point is on, my lords, Constituent Assembly and the nature and the nomenclature of Constituent Assembly. Mr. Gopal Subramaniam specifically highlighted that there are no hierarchies. That was his submission, that there are no. At a normative level, that's an absolutely correct statement. There cannot be any hierarchies in Constituent Assembly. However, there are not many things that move on a normative level in Jammu and Kashmir. There are 3 facts in this regard that my lords need to see. There are 2 kinds of constituent power. One is original constituent power, and the other could be derivative constituent power. It was on this jurisprudential basis that Keshwanand Bharti was delivered and thereafter other judgments, which state that the original constituent power is always with the original Constituent Assembly, the plenary power. But derivative constituent power is something that is always with further legislatures, the parliament in this case. Therefore, the question that we need to interrogate is whether the Constituent Assembly of the Jammu and Kashmir Constituent Assembly had any original constituent power. The 3 facts, which according to me clearly point towards the fact that they had no original constituent power, were A, it was established under the proclamation of a Maharaja that had already signed an instrument of accession. Number 2,
Just 1 second.
it's there in the 3 page.
Yes.
Number 2, the Maharaja had already issued a proclamation dated 25/11/1949, recognizing the supremacy of the Indian Constitution. And number 3, unequivocally, Article 1 was in force. So on the date in 1951, when the proclamation
establish the Constituent Assembly of Jammu and Kashmir was issued. The Maharaja, who was not a sovereign, could not have passed a better title than what he had. If he was not a sovereign, the Constituent Assembly of Jammu and Kashmir could never have been a sovereign Constituent Assembly, could never have established a sovereign constitution. The suggestion from the other side is that under 370 sub-article 3, they could have severed their ties with India at the time of dissolution of the Constituent Assembly. My lords, I submit that is an absolute impossibility as far as the Indian Constitution is concerned, because Article 1 would have applied to them irrespective of
Agarwal,
the nature of
page,
Article
which
370.
is the page of your written submission in the?
That's page 2.
No, in the volume 3.
My lords, that is not there in volume 3.
Add kar do usko.
Plus, if my lords allow,
All right, thank you.
please, my lords, just one more aspect, my lords.
Yes.
If the JNK Constituent Assembly had no original constituent powers, it automatically exercised only derivative constituent powers. If it is exercising derivative constituent powers, it is akin to a legislative assembly. My lords, one of the letters that was highlighted by Mr. Shankar Narayan was a letter by Rajendra Prasad to Mr. Nehru. My lords may remember 1952, 6th of September, I think, 1952 by Rajendra Prasad. That letter finds mention in Mr. Noorani's book at volume 20, page PDF 222, I believe. Mr. Noorani has done a lot of research. He should have also pulled out the letter which was written by the then Prime Minister, Mr. Nehru, in reply to the letter of Rajendra Prasad. Mr. Nehru wrote a letter dated 7/11/1952 to Mr. Rajendra Prasad on a host of issues, after Mr. Rajendra Prasad had also written a letter to the then Home Minister K.M. Munshi. And he highlighted the fact that how this issue has been discussed with the law officers of the union at the highest level with Mr. Gopalaswamy Iyengar and with other people. I have annexed it to my note, my lords. And therefore, requested the president, requested being the word, requested the president to consider passing the CO. That was on 7th of November 1952. Within 8 days, my lords, the learned president passed the CO 44, which was 15/11/1952 under 373, thereby changing Maharaja to Sadar Riyasat. Therefore, my lords, I think the SG had also pointed it out that actions speak louder than words. That is
Yes,
all that I
yes, Mr. Vikram.
Well, I'll just make a small submission. Well, everything is, my submission is this. My lords have seen the original constitution. The original constitution.
Biju, move towards the center.
Well, the original constitution, there were transitional and temporary provisions. It wasn't, the special provision was subsequently added as an amendment at a later point of time. So the original constitution in this chapter was as to temporary and transitional provisions. So the very fact that this is taken to be a transitional and temporary provision means that this is the entire objective of the original part. Subsequently, a large part of it, my lords will recall, has from 75 to 91 have now been amended out. So the original intention of including 370 in that chapter, and it was in the genus of that, this was a transitional provision. And my lords will see 391 and 392, there were presidential powers which were given to make amendment.
Thank you, Mr. Banerjee.
My only submission is this was permissible to
This has been already argued, Mr. Banerjee.
Thank you, Mr. Banerjee. Now, Ms. Pathak, come along, come forward. 1 second, we'll call out. We are calling out people. Don't jump the gun. Yes.
1 minute.
1 second, Biju.
Yes, I'm sorry.
Yes, Ms. Dave, what do you want to?
I'm appearing in an IA 171722 of 2019.
So what's the point, tell us?
Well, the point that I'm making is, the permanent residentship, no one has talked about the rights of the women that were taken away. So the permanent residentship would not come to the women who have married outside the state of Jammu and Kashmir. So, my lords,
That was set aside. That was ultimately constitutionally.
yes, my lords, state of JNK versus my lords, Dr. Sushila Sahani 2002 judgment. In fact, the full bench of the Jammu Kashmir High Court held that they will have permanent residentship even if they marry outside. But the state then, my lords, the learned AG there made a statement that they will not get, in fact, my lords, the right to employment, right to scholarship, as well as the right to hold immovable property was taken away if you marry to a person who is outside the state of Jammu and Kashmir.
Thank you.
Well,
Mr.
it's my written
Did you?
submissions.
Yes, we'll take.
I have,
What is your page of the written submissions?
well, it's Well, I'll give it to the learned court master, my lords. We had submitted to the nodal council.
All right.
2 pages only, my lord.
Volume 3, right?
Yes, my lords. There's one,
Yes, Biju.
my lords. We have got these rights now after 2019. Can a writ petition filed under 32 take away fundamental rights given to the other citizens of the country, my lords? Is my respectful submission. I'm obliged, my lords.
Yes, my lord.
Yes, Biju.
I am appearing for my client who is a retired major. He dedicated his substantial time in the area in question, which is J&K. And my lords, my IAS 171000 of 2019 petition civil number 1082 of 2019, my lords. Kindly note this because my.
Biju, just make a point now.
Yes, my lords. 171000 of 2019 is WPC number.
We'll see that, you just make what.
Just what's the substance? What's the point on substance?
My point is this, my lords. Before that, my lord, page 5152 to 525 of volume 3, my written submissions, where I substantiate what are the ground realities, where I substantiate what was happening, as my lords already asked. My lords, what is after going again and again, 370 subarticle 3 provides so there is a special provision. And if it is non-functioning, then what is the way out?
This point has been argued.
What is it?
Come on now, tell us something.
What is the next remedy, my lords? My respectful submission, my lords, is extremely clear in the Constitution of India, Article 368(1). Then 2 is saying that, 368(2) says that if so and so articles or chapters, if you are going to touch, or if you are going to touch basic structural principle, then you have to have the ratification of the 50% of state governments. In that subclause 2, there is nothing to do with 370. So 368(1) is starting itself is, my lord, extremely important, that language, that notwithstanding anything contained in.
Well, thank you.
Notwithstanding
Thank you, Biju, we got the point. We got the point. Thank you. Sir, at the back.
One more.
Biju, there's somebody at the back from Srinagar, Jammu, who is.
Point, my lord. This is one area, my lord. Then my respectful submission, my lords, what I did again and again, my lords, I was repeatedly reading my lord judgments from 1950 onwards, at least 5 judgments, which are constitutional judgments, saying that there is every power for Indian Parliament and the President of India.
Thank you.
That I, my lord, separately indicated in paragraph.
We'll see on that. Yes. What is your point?
I'm grateful just for the time. Lords, I'm appearing in 108/43 of 2018, Lords. It said there's an IA filed, Lords, by the Bar Association, High Court of J&K and Jammu. Now, Lords, I adopt, Lord, the submissions of the SG and everybody, Lord, who is supporting this, Lord, CEO. One submission, Lord, if the Honorable Court would permit me, is that whether, Lord, at this 76th year of our association with a country, a question mark, Lord, on our nationality also would not hit, Lord, in the extended interpretation of Article 21. If I would seek the Honorable Court's indulgence, Lord, that whether right to live with dignity, Lord, starting from Maneka Gandhi's 78, would also include, Lord, a right to have a nationality after having lived with the country and identified oneself with. So, Lord, we take pride in being Indians outside of India. But when it comes, Lord, within India, can there be somebody, Lord, allowed to raise a question mark on our nationality? Because, Lord, when I was, Lord, following this, Lord, debate on the VC from J&K, questions like referendum also, Lord, were addressed. Now, in this, Lord, 75th Golden Jubilee, which we say, if, Lord, at this point in time also, a question mark on our identity with a particular nation where we have contributed and will live with pride within India, if this is still, Lord, is hanging in balance, though, Lord, we owe our, Lord, gratitude to the Constitution that this debate is still permissible. But then, whether the Constitution, Lord, can be so flexible as to include a debate also as to a person who has contributed a lifetime. No, this is the 3rd generation, Lord, into it. Now, from 47 onwards, we are now, Lord, in 2023. And in 2023, Lord, if I have to prove to somebody that I am an Indian, whether, Lord, my life is actually a life of dignity,
is, my lord, my humble submission. I'll seek honorable bench, my lord, indulgence.
Thank you very
I'm
much.
grateful.
Thank you.
Lords, 35A is linked to section 6 of the Constitution of Jammu and Kashmir and is linked to 370. If 272 and 273 is not upheld, what the consequence is that there is a tap on the application of the Constitution of India, including Part 3, which can be turned on, turned off at the discretion of the state government, which by itself is inherently discriminatory, abusive. Yes, which has been therefore, apart from IR Coelho, I think most important is Puttaswamy, where your lordships have upheld the socio-economic interpretation, because for a long time, fundamental rights were essentially social in nature, but an economic angle has been brought about. Our problem is we are being deprived of that. One very brief point, my lords, the consistent position of Republic of India, and I deliberately say Republic of India, before the United Nations Security Council is that there was no sovereignty of any kind, slightest nature, residing with the state of Jammu and Kashmir, neither under international law, nor under comparative constitutional law. For comparative constitutional law, there's an opinion of Dr. Ambedkar, which is in my submission, where he said why there is not even an iota of sovereignty with any princely state, including state of Jammu and Kashmir. In international law literature, it is very clear, settled position of customary international law, which was also taken by the Republic of India in the Security Council in MC Chagla's speech, and also Krishna Menon's speech, very clearly spelled out that under international law, there's no possibility of any such constituent, which is an integral part of India, to have any sovereign right. So that is clear. So therefore, no question of Constituent Assembly or Maharaja having any sort of sovereign power. In fact, it was made expressly clear in the Security Council itself by both of them that aspect rests entirely with the Union. So what is being now called as residual sovereignty can't conceptually exist. It contradicts the very idea of sovereignty propounded by Bentham, or even by Max Huber. Therefore, sovereignty, there is only one sovereign. All that they can have is legislative competence, that is also to minimal extent. Apart from that, there was a major argument which was made that instrument of accession had to be approved by JK Constituent Assembly. It wasn't necessary. The only requirement was Section 6 of the Government of India Act. This was the consistent position again put forward by MC Chagla before the United Nations Security Council. Also under section, one very last point, India was the successor state which included princely states. That comes from section 311 of the Government of India Act. Therefore, by virtue of that, India already a singular entity where all sovereign authority rests with the Union and the constituents don't have any other power. To use the phrase of Krishna Menon, they are sub-sovereign entities.
Yes.
Advocate General,
and nothing for
UT.
Yeah.
United Nations. This is past history. There is nothing pending in United Nations or any. It is our internal.
Yes, my lords. Yeah.
Yes.
Only thing I was saying, that's the position, that there's no such internal.
Being the AG, first of all, I subscribe to the submissions made by attorney and solicitor general and my colleagues on this side. One aspect perhaps need to be brought, but the basic fundamental rights include the health also. And health generates from the health medical education. All judgments, whenever it would come, I am passing a judgment to Lordship just now. But kindly see the plight in J&K. Whenever it comes to the taking a health care, the point would be that we, because of 370, will not allow those benefits which are emanate from Article 21 to flow to J&K. Now I am passing the judgment of this Honorable Court. But whenever this issue comes, this is 1984, where they say, yes, for the rest of the country, that sending 70% of seats and 30 for local is funded. But when it comes to J&K, even this Honorable Court says, we'll wait till the time comes. How long will this medical facilities, which are, just have a look to these judgments. In this last paragraph, the court says, so far as J&K and Andhras are concerned, we are told that there are some constitutional provisions, and therefore we deal. The result was that for so many years, the rest of the state of Jammu and Kashmir and now UT remained deprived of the basic fundamental rights, including the medical education. So let's just have a look to this.
We'll have a look at. Thank you, Mr. Advocate General. Thank you.
There's a short
All right,
holding my
everyone 1 minute each. Yes.
Yes, my lord. Just before I conclude, all speeches, because I know that time
all exercise, my lord, understanding and the literature, one word is very important. All my lord, leaders, including Mr. Sheikh Abdullah, in unequivocal terms said accession, not the aggression. In the parliament on 8 June 48, 8 January 48, everywhere. No blood, even at this stage of 75 years, yet we have to define our relationship with it. But as Article 371, Part D, Part 3, they were discussed so. In all cases, blood, we are the integral part of this great nation, Union of India. All arguments to the contrary are too late in the day when the Constitution of India had all in its place, and blood, now it is only academic, otherwise we are a part of that. I'm grateful.
Thank you, Mr.
Lord, the short submission. This amendment A cannot be seen as a silo in light of the larger transformative nature of a constitution. 3 bullet points that come in it. The violation of rights of those who are persecuted is so extensive, my lords, that it has been recognized as a grave human right violation in 2019. A violation, my lords, which is considered an international crime in international law, therefore attracts customary international law and is a jus cogens norm. So therefore, my lords, when such an acknowledgement does come in, really a case for restorative and transitional justice does arise. So clearly, my lords, those who have been persecuted and they want to go home, it will have to happen that security is ascertained and restorative and transitional justice does arise. So fact-finding missions, truth commissions, transitional commissions, therefore become the norm. Unless and until, my lords, an amendment of this nature does not come in, that takes away the conditions of oppressions that were there and that ensured that they were not only persecuted but had an exodus in 89 and 90 is not taken away, this higher feature cannot really be attained, my lords. So therefore, my lords, I submit that this has to be seen holistically. And attributing of responsibility. My lords.
You can put it in your note. It's in your note.
Millards.
Now, I'll limit my intervention on just 2 aspects, my lords. One is the proviso under Article 3, my lords. The contention of the other side was that the requirement of taking the views of the state legislature is a condition precedent. My lords, as the learned Solicitor General has shown already that wherever Article 356 was invoked, this proviso to Article 3 was suspended. Secondly, my lords, the views of the state legislature under the proviso are not binding on the parliament. Your lordships have so held in Babulal Parate's case. Thirdly, my lords, Article 3 is a plenary power. So any interpretation, any construction cannot be given to the requirements of obtaining the views of the state legislature, which denudes from this plenary power. My lords, the second argument is the Rajagopal case, Karunanidhi's case, which was cited by the petitioners, is wholly inapplicable, my lords. That is a 1-paragraph judgment, and the finding that is given in that judgment is that dissolution of state assembly will not be a ground to hold that the constitutional machinery has been broken down in the state. Rajagopal case relies on UNR Rao, which is delivered by the same bench of your lordships. In UNR Rao, the contention was that a writ of quo rento was sought against the Prime Minister and her cabinet. The contention was that since the House of People has been dissolved, and since the cabinet is responsible to the House of People under Article 75(3), the president should dismiss the cabinet. Your lordships rejected this contention and said that Article 75(3) will only apply where the House is not dissolved or prorogued. So this case is wholly inapplicable. My lords, my note is volume 6, PDF page 50. Kindly consider that. I'm grateful.
My IA is, my lords, 146764, my lords.
Yes, Mr. Bhushan, what do you have to say?
Yes, my lords. I have to say, I will make only one summation that this temporariness and permanentness of Article 370 has to be looked through the prism of word further in the preamble of Jammu and Kashmir, read with Section 3 and 147 of Constitution of Jammu and Kashmir also. Even Constitution of Jammu and Kashmir has not given power to itself to amend Section 3, where it is said that it is and shall be the integral part of Jammu and Kashmir Constitution of India. And second is will of people. This was argued strenuously.
Lordship, I appear
Yes,
for,
Dr. Khanna.
Lordship, I appear for Youth for Kashmir, Pannu Kashmir. We were the people who were displaced in 1990s, whom I represent. Lordship, my first point of submission is when the instrument of accession was signed, that day it was complete and formal integration with India. And
that point has been made. What is the next point?
Lordship, the second point that I wanted to make, that because of 370, there was no economic integration with India. That was we were making. And the other point I wanted to make was regarding the women's right, which Ms. Pathak has made. And Lordship, the final point I want to make it till 2016, even transfer petitions could not be filed in this court under the regular provisions. We have to approach under 32 or in the other provisions.
Thank you. Yes, yes, sir. What do you have to say?
19618, my lord. In my matter, my lord, no counter, no students has been filed, my lord. I got a letter circulated on 27th July, my lord, saying therein that I shall be able to file written submission only after hearing both the parties. Now I am kindly be allowed to.
What? And what is that SLP?
185, my lord.
Filed by whom?
Filed by whom actually? You are the SLP petitioner.
My lord.
What is the order that you are challenging?
My lord, I am challenging the order passed by the High Court, my lord. I saw there, my lord, to declare Article 370 a left provision. Second, my lord, declare separate constitution for the J&K wide ab initio.
That is
My lord, that I am seeking permission. I am seeking permission to file written submission. In view of my letter, my lord, which I circulated on 27th July.
So we'll come back after.
Yeah, why, during recess, may I just
going
file
through my
my submission so that they are on record?
My lord, after going through my written submission, my
They are
lord,
longer
Because
than
I have
the
to
main
reply, Malad, I have to reply. Put
They
it
are
down on
longer
paper.
than the main arguments.
I'm sorry?
You can open your submission.
My lord,
We'll see.
permission.
That's what I'm saying, Malad, that I will.
We'll hear you, Mr. Sibil. After lunch, we'll
Yes,
hear you.
in the meantime, I should be able to file, Malad.
They are longer than the main submission.
One second, you have filed hundreds of documents. I never objected. Even my first submission, you never. What is all
Reflect on
this?
it at lunch. We'll
My
hear
lord,
you at lunch.
written submission may kindly permitted to
Where's
file,
your-
my lord.